Good afternoon, everybody. We thank you all so much for joining us today for our webinar, Make It Make Sense, Navigating the Impact of Recent Executive Orders on Massachusetts Employers. We have a lot of material to cover in the next hour, but before we delve into the discussion, we're going to do some quick introductions of the employment law team here at Krokidas Bluestein. To first introduce myself, I am Jill Meixel. I'm a partner here and the head of our employment practice and the co-head of our litigation practice. Now I'm going to turn it over to Bettina and Cassidy to introduce themselves as well. Bettina?
Good afternoon, everyone. As Jill mentioned, my name is Bettina Toner. I'm a partner here at KMB, where I practice in the firm's education and employment practice groups. I represent Massachusetts public charter schools and other educational entities in a wide range of employment and student services matters. So it's great to see a lot of our charter school friends and other educational clients here today, as well as others.
All right, and I am Cassidy Mills, and I'm an associate in KMB's litigation and employment groups.
Okay, let's get started here. I think we can all agree that the last 7 weeks has been an absolute whirlwind, with the shift in the presidency and power causing significant upheaval federally and all around the country. This marked shift has come in varying forms, the most immediate and prominent being the flurry of executive orders that were issued almost immediately after President Trump was sworn into office. In addition to those executive orders, there have been other directives from the federal government as well, in the form of Dear Colleague letters from the United States Department of Education's Office of Civil Rights and pronouncements rescinding prior guidances of various federal agencies, including the National Labor Relations Board and the Equal Employment Opportunity Commission. Our goal today, in the short time that we have together, is to help you understand and navigate these ever-changing directives and various interpretations of the law. In discussing the current legal landscape, we will provide you with guidance and tips to help you maximize your ability to promote and protect your organization's underlying mission and objectives while also complying with the law. Before digging into the agenda, I want to highlight that we have a broad mix of attendees here today who come from nonprofit organizations, schools, and for-profit entities. Our goal is to provide all of you with some nuggets that you can take away with you to help navigate through this time. I also need to give the standard caveat here that this presentation does not constitute legal advice, but if you do need advice on any specific situation, you can always feel free to reach out to any of us. Next slide. I now want to quickly highlight what we plan to cover today, and it's a lot. We're going to start with Cassidy, who's going to provide some stage setting information, providing background on executive orders and their impact and state and federal anti-discrimination laws. Then Bettina will address how to navigate the tension between state and federal law, particularly in times like these where they may be at odds with each other. Next, I'm going to talk more about the present state of diversity, equity, and inclusion in light of the executive orders and discuss how you should approach DEI moving forward. We are then going to turn the discussion to Bettina, who's going to discuss the present state of LGBTQ+ rights and gender identity and the state of the law in light of the recent executive orders. Cassidy is then going to discuss immigration and significant changes in enforcement under the new administration. Cassidy is then going to review some recent changes and retractions to guidances issued by the National Labor Relations Board, as well as EEOC enforcement in light of the new administration. And then Bettina is going to wrap up and discuss some key takeaways from today's presentation. If we have time today, we do plan to take some questions and answers, but I encourage you, since we have a lot to cover and we may not get there, please don't hesitate to put questions in the chat. And if we don't get to them today, we plan to follow up with a client alert addressing your questions. I'm now going to turn this over to Cassidy to address setting the stage.
And you can actually go ahead and go to the next slide, Claire. All right, so this slide just has a list of some of the relevant executive orders that we're going to be covering today. We're not going to talk about all of these, but as you can see from this slide, there are executive orders relating to DEI, quote, ending illegal discrimination and restoring merit-based opportunity, end quote, which, as Jill is going to explain later, also relates to DEI. and also, quote, gender ideology extremism, and immigration. Next slide. Before we sort of dive into the meat of these, we wanted to take a step back for a second, because there are a lot of questions about, what does the president have the authority to do through executive orders, and what effect do these really have? And ultimately, this is a separation of powers issue. So if you think back to your grade school civics class, in theory, we have three co-equal branches of government. We have the legislative branch, which is Congress, which makes the laws. We have the executive branch, which is the president, which enforces the laws. And we have the judiciary, which interprets the laws. I say in theory because the limits are certainly being tested right now, and it is a bit of an open question as to whether and how much the president will respect the authority of the other branches of government, and also whether the other branches of government might cede some authority to the president. But what is an executive order? An executive order is essentially just a written directive to the federal government, ordering the government to do something to carry out the law. And the authority to do this comes from what's called the Take Care Clause in Article 2 of the Constitution, which is all about the executive branch. And the Take Care Clause says that the president shall take care that the laws of the United States be faithfully executed. So essentially, executive orders are directives to the federal government for how it is going to enforce the laws. It's important to keep in mind that an executive order does not override an existing federal law or judicial precedent, but as we're going to discuss a little bit later, it can undermine existing law either by lack of enforcement or maybe by enforcing laws in a way that were not necessarily intended. So we'll talk more about that in a little bit. So it's a little bit of an open question right now as to whether the rule of law is going to hold. As Jill's going to discuss later, a lot of the president's executive actions are already being challenged in court. It's possible that we could have a situation where a federal court might say that a certain directive is unlawful, and hopefully that would be the end of it. But with this administration, it is possible they could ignore the court order, do what it wants to do anyway, and then might end up in a constitutional crisis. So this is not to scare you, but just sort of where we are in this moment. Go ahead to the next slide. Okay. So this slide is just to give you an overview of the anti-discrimination law landscape. So these are some of the federal laws that are going to be affected by these executive orders, and then some relevant state anti-discrimination laws, which might help fill in some of the gaps. So first we have Title VII of the Civil Rights Act of 1964. This is the federal statute that prohibits discrimination in employment on the basis of race, color, religion, sex, and national origin. These are what we call protected classes. Sexual orientation and gender identity are not specifically included, but as Bettina is going to talk more about in a little while, the U.S. Supreme Court has interpreted Title VII's prohibition on sex discrimination to include discrimination based on sexual orientation and gender identity as well. Next, we have Title VI, which prohibits discrimination by programs receiving federal funds on the basis of race, color, and national origin. And then we have Title IX, which prohibits discrimination in educational programs receiving federal funds based on sex. So that's sort of the federal law landscape. Under state law, we have Chapter 151B, which prohibits discrimination across a bunch of different areas, including employment, housing, and lending. The protected categories under Chapter 151B are broader than those in Title VII. And as relevant to our presentation today, the list of protected categories in Chapter 151B specifically includes sexual orientation and gender identity. There's also the Massachusetts charter school statute and its implementing regulations, which require charter schools to adopt a non-discrimination statement that similarly includes a broad range of protected categories, including sexual orientation and gender identity. So now I am going to turn it back over to Bettina to discuss what happens when there is a difference or a tension between state and federal law.
Next slide. All right, so with that backdrop in mind, let's talk about what happens when there are inconsistencies between federal and state law. So we're talking about actual law here, right? So mainly statutory law and case law. And as Cassidy just explained, an executive order does not override existing federal or state law. So in the context of the tension between existing federal and existing state law, you may recall, again, going back to your civics class from middle school or high school, that the Supremacy Clause of the US Constitution provides that federal law is the so-called supreme or highest law of the land. And as such, it preempts other laws that are in conflict. So again, as a reminder, the preemption doctrine refers to this idea that a higher authority of law will displace the law of a lower authority of law when the two authorities come into conflict. So, as a general matter, federal law will preempt or override inconsistent state law as a general matter, with some exceptions that we won't get into today. However, there are some contexts, and particularly civil rights law is one, where a state may enact laws that provide more protection than federal law provides. So, some examples of that, and you may be for our school friends that are with us today, in the context of student record privacy, for example, schools are familiar with the concept of the federal FERPA statute, student records privacy law under federal law. In Massachusetts, analogous state law, which provides protections for student record laws. For folks that are familiar with both of those statutes, you will know that, or you will recall that Massachusetts student records laws are narrower, or another way of saying that is they provide more protections than FERPA. So in that context, student records law under Massachusetts law provides more protection and would be the controlling law in that situation. And so we see situations where folks are are being asked to share student records, for example, and someone is trying to analyze it under federal law, but Massachusetts law, when we're here in Massachusetts, would control if it provides additional protections. And another example, just to sort of put this into context, is Massachusetts state law has long provided protections against discrimination in employment to individuals on the basis of sexual orientation and gender identity, going back to that Mass General Laws, Chapter 151B that Cassidy just told us about. So that state law has been in place, for many years now, and it existed well before the now overridden 2024 Title IX protections. So all of that is to say that employers cannot ignore state law protections, even though they've been diluted or in some cases eliminated under federal law or by executive order. So just keeping that in mind when you're getting all of this information on the federal level, that we still have very robust protections on the civil rights in the civil rights arena here in Massachusetts. And for the most part, and Joe will get into this a little bit more, the guidance has been that, you follow state law if it provides additional protection. And so that's the key to keep in mind. So I'm going to hand I'm going to hand it back to Jill, who will discuss some potential impacts of the recent executive orders on DEIA policies and programs.
Thanks so much, Bettina. So now we're going to turn to a discussion of the actual and potential impacts of the executive orders and other recent federal action relating to DEI, LGBTQ+ rights, and immigration, among other areas. I'm going to start this discussion with a focus on the two executive orders relating to diversity, equity, and inclusion, which seek to delegitimize DEI in the public and private sectors, even if such efforts are not actually legal. As you will see momentarily, the specific substance of the executive orders relating to DEI is extremely far-reaching, confusing, ambiguous, and has led to many questions regarding their legality, their enforceability, and their place within the structure of the anti-discrimination laws of this country. In order to address what these executive orders actually mean, I'm going to tackle this by first level setting and taking a very high level look at what these two executive orders actually say. Then I will turn to discuss what the executive orders seem to mean. And finally, I will discuss how the executive orders will or might impact your organization or your school, and what you can and cannot do at this point in time to further your missions while also at the same time complying with the law. Of course, through this discussion, we should all recognize that this is such a fluid situation that there may be changes even before we finish this webinar. You can go to the next one. So now I'm going to briefly highlight some language in the two executive orders relating to DEI and set the stage and help explain what this means and where we go from here. So the first executive order that was issued relating to DEI is Executive Order 14151, ending radical and wasteful government DEI programs and preferencing. I have boiled this executive order down to just a few key demonstrative points. As you will see from this slide, this executive order makes very broad pronouncements, focusing on putting an end to illegal and immoral discrimination programs going by the name diversity, equity, and inclusion. In addition, this executive order directs the termination of all discriminatory programs, including illegal DEI and DEIA mandates, policies, and programs. I want to point out here, as a representative example of what I'm going to discuss momentarily, that the executive order indicates that it seeks to end discriminatory programs, but then it references illegal DEI and DEIA mandates, which seem to try to get the reader to draw the conclusion that both DEI and DEIA mandates are actually illegal. And as we're going to discuss momentarily, this is simply not true. In addition, this executive order further directs agencies to terminate certain programs that tie in any way to DEI. It's important to note, as you will see in the third box on the screen, that the executive order directs termination of a variety of DEI-related programs, but then it says to the maximum extent allowed by law. Therefore, if such termination is not permissible under the law, the executive order's authority does not trump judicial action. And finally, this executive order directs agency heads to provide a list of organizations and schools who receive federal funding to advance DEI, DEIA, and environmental justice objectives. Here, the executive order again implies that advancing these objectives is actually illegal. Now let's look at the second executive order. And again, this is just a high-level overview of, if you would go to the next slide, please, thank you. The second, if you go to the prior slide. Of the second executive order that focuses on diversity, equity, and inclusion. And this one is Executive Order 14173, and it's entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. Notably, this executive order is aimed more at the private sector, but essentially mirrors the same themes as the executive order that we just reviewed. So this executive order provides that dangerous, demeaning, and immoral race and sex-based preferences are DEI and DEI programs that violate civil rights laws. While race and sex-based hiring is not permissible, this executive order seeks to equate such preferential hiring with DEI and DEIA programs. This executive order also highlights that those receiving federal funds must certify compliance with all anti-discrimination laws, which includes certifying that none of their programs, their DEI programs that is, violate such laws. After this executive order was issued, many companies who actively promote DEI objectives, immediate reaction, understandably, was panic, with concerns that they may thereafter be ineligible for receipt of federal funds if they have any DEI programs in place at all. Of important note, and as you've probably noticed from these couple of slides, the executive order does not define what constitutes illegal DEI, nor does it define anywhere how it's interpreting and what DEI or DEIA means. Next slide, please. So now that we've reviewed sort of the language very high level of these two executive orders, let's talk about what they mean and how you could be impacted. You will notice that throughout those executive orders that we just took a look at, there are references to complying with anti-discrimination laws. While in the same breath, essentially prohibiting the use of DEI in any manner in the workplace, calling DEI illegal. The executive orders improperly conflate compliance with anti-discrimination laws with eliminating wholesale DEI from the workplace. However, it is critical for all of you to understand that DEI is not illegal, and I simply cannot emphasize this point enough. Without defining what DEI means, the executive orders are written in a really confusing way that seems to, at first blush, lead to the conclusion that DEI is actually illegal, or if it's not illegal, that it's a bad practice and that it should be removed from your missions, from your programs, and from your operations, or you will suffer some adverse consequence. For example, we have seen in the news and whatnot that some higher educational institutions, some larger companies, and other entities have really gone out of their way since the issuance of this order to remove every reference to diversity, every reference to equity, and every reference to inclusion and accessibility from all public-facing materials, because we are being told that DEI is illegal. But again, it is not, and courts are now really starting to parse this out. Ultimately, as we're going to discuss a bit later, much of how you proceed here really depends on your organization's risk tolerance, which is going to be different depending on the circumstances surrounding your missions and the present state of the law. I do want to emphasize again, and I know I've emphasized it already, but it's super important, that DEI is not the same as truly illegal preferences in hiring or affirmative action. And the orders really try to conflate these things, therefore conflating what is legal with what is illegal and vice versa. Since January 20th, activist groups have been ignited to action by challenging these executive orders. And this really, we go back to Cassidy's overview earlier of the separation of powers and how executive orders work. After the issuance of the executive orders by the president, we have now seen the judiciary come into the mix. And courts are now starting to claw back the substance of what these orders mean and what the federal government, through an executive order, is actually allowed to do. So I want to highlight, just by way of sort of representative example, two recent cases that have paused enforcement of some of these executive orders. The first one, which is the box to the far left, is a recent case out of the District of Maryland. You've all probably heard about this case. It came down in late February, and at that time, the court in Maryland, the federal court in Maryland, granted a preliminary injunction, and they found that the two executive orders that we just reviewed are unconstitutionally vague and may violate free speech. In issuing the injunction, the court determined that employers are not required to certify compliance with these executive orders relating to DEIA and DEI, and said that the federal government cannot enforce compliance of these orders, including by stopping funding or permitting remedies under the Federal False Claims Act for failing to certify compliance. The injunction also blocked the requirement that the federal government terminate equity-related grants or contracts and blocked enforcement against entities receiving federal funds that have DEI programs. I also note that as recently as yesterday, the court in this case issued another decision clarifying that the enjoined parties including federal executive agencies, departments, and commissions who were not specifically named in the case. So the case named a number of parties as defendants, and the plaintiffs in that case moved to confirm that the named defendants it wasn't an all-inclusive list. And the court granted that motion for clarification. And I should note that this case is currently on appeal to the Fourth Circuit, and it wouldn't be shocking if it ended up before the Supreme Court. In another case out of the District of DC, which came down a few days after the Maryland case, the court indefinitely extended an injunction on the federal funding freeze for organizations and schools who are continuing to operate DEI programs. And as I noted a moment ago, these cases are all really fluid and developing as we speak, and you should continue to keep a close eye on them, particularly as they likely make their way up to the Supreme Court. Next slide. So in addition to developing case law, such as the case law that I just addressed, there's state law enforcement is also keeping a really close eye on how these cases play out and how their states will be impacted. And I wanted to bring to your attention a really important, really impactful guidance that was issued in February by 16 state attorneys general, including the Massachusetts Attorney General, Andrea Campbell. And I believe we're going to put a link in the chat to this guidance, which I strongly encourage all of you to read. It provides incredibly helpful tips for your organization in determining what is and what is not legal DEI. I want to highlight a few takeaways from this guidance. First, the guidance highlights, as I indicated a few moments ago, that DEI is not illegal. And instead, it emphasizes that DEI helps establish a positive workforce culture and significantly aids in helping to reduce discrimination in the workplace. The guidance reiterates that DEI is not affirmative action, but that DEI seeks to ensure that an organization's processes and procedures are fair for everyone. Further, the guidance provides that DEI, when implemented correctly, allows an organization to recruit and retain the very best candidates while fostering an inclusive workplace. I encourage you to take a look at the tips and guidance provided by these attorneys general as you work to ensure that your approaches, your policies, and your practices are compliant and consistent with anti-discrimination laws. And the guidance really does provide a number of helpful tips. It's not super long, and it's very much worth reading. Next slide. So now I want to quickly sum up what I have discussed in the last few slides before getting into some specific practice tips. So as I've discussed, and just to reiterate again, policies and practices that promote diversity are not the same as preferences in hiring or promotion based upon protected characteristics. As employers, you should incorporate DEIA best practices in order to reduce liability risk to your organization by affirmatively protecting against discriminatory conduct that violates the law. I note that employment discrimination laws generally require employers to pay attention to the impact that certain practices have on different groups based upon protected characteristics. Next slide, please. So now we talk a bit about some potential impacts and risks to you. As we've discussed, it is really important to keep an eye on how these cases that we just discussed and many others play out, because they're ever evolving and quickly evolving in the legal landscape. And even more critically, it's important for you to keep apprised of whether the government complies with the court decisions with respect to the present injunctions in place prohibiting the government from freezing funding. And as Cassidy said earlier, this is really a test to the rule of law. So just because a decision is issued doesn't necessarily mean that we know what's going to happen yet. So you all should pay very close attention to see if in the face of these court decisions, if the government is complying or if they're not complying. And that is a test of the rule of law. You should also be on the lookout for whistleblower claims. There are folks watching what you do and what you say and looking for opportunities to use your organization's practices and policies as a testing ground for litigation. You're likely going to see whistleblower cases popping up, hopefully not against your organization, but just more generally. And it's important to keep an eye on those to see how they play out. The potential risks to your organization ultimately are going to become more clear as these cases play out in the coming months and as we determine the extent to which the rule of law may be tested. Next slide, please. So now the next few slides are going to discuss some practical tips and compliance measures that you all can take moving forward in this confusing legal landscape. So as I've referenced throughout this presentation, direct hiring and recruiting that's aimed at a specific protected class is not permissible. Similarly, as the Supreme Court ruled in Students for Fair Admission case against Harvard, quotas or admissions targets based on membership in a protected class are not allowed. So now let's talk about some best practices and what likely is permissible. Next slide, please. So this slide contains sort of an overview of some of the practices that appear to still likely be permissible. And I just want to go down them because I think they're incredibly important. So first of all, if you have a DEI-based mission, that's, again, assuming that you're not violating the law in the way that I just discussed, that's permissible. You can have a mission that emphasizes inclusion, that emphasizes fair access, and emphasizes opportunity for all. In addition, the second box, teaching, professional development, and curriculum that discusses diversity, equity, and inclusion topics and provides equal access to all, that's still likely permissible as well. In addition, initiatives that focus on different perspectives, different experiences that aren't tied to any specific class, that is also permissible. Race and gender neutral approaches, also permissible. In addition, DEI focused on crediting personal experiences, demonstrated ability are also permissible. Programming and curricula that are focused on particular groups. So you can still have groups that focus on a particular protected class, such as gender, sexual orientation, or race. However, you need to make those groups open to everyone, and you should not take any actions that might be interpreted as discouraging certain groups from attending those meetings. Finally, the last box on the left, and this is really important, you should review your policies and procedures very carefully. You can still have, and you should absolutely have, anti-harassment policies, trainings on things like unconscious bias, inclusive leadership, and disability awareness. However, you can't require certain racial groups to attend those trainings. With respect to recruitment and hiring, a few notes of things that are still permissible. You can hire and focus on individuals' experiences, barriers faced by students and employees from specific groups, but are made available to everyone. In addition, you can make recruitment widespread to attract a larger pool of candidates. And finally, you may want to set criteria for evaluating applicants and students that focus on experience and skill. And I'll just note that Attorney General guidance that I mentioned a few minutes ago includes some additional best practices that I would recommend you take a look at. So ultimately, each organization is going to have to determine what your risk tolerance is. And this may be driven in part based on the extent of your federal funding, even though presently there's an injunction in place that prohibits the government from acting accordingly. But it really depends largely on how these cases play out. Thank you. And now I'm going to turn this over to Bettina to address LGBTQ+ rights and gender identity.
Thanks, Joe. All right, so let's talk now about protections against discrimination on the basis of sex and protections specifically on the basis of sexual orientation and gender identity. Although LGBTQ protections fall under the general umbrella of anti-discrimination efforts included under DEIA, they have been under particular attack, as we know, under this administration. So first, to set the stage, I feel like we have a lot of stage setting that we've been doing, but just to set this stage, at the federal level, a reminder that the president issued two related executive orders, Executive Order 14168, which declared that there are only two sexes, male and female. And then relatedly, Executive Order 14201, which provides that the federal government will interpret Title IX under the definition of Executive Order 14168. So that one I just mentioned with respect to their executive order saying that there are only two sexes, male and female. And as Cassidy shared earlier, just a reminder, Title IX applies to all educational institutions that receive federal funding and prohibits discrimination on the basis of sex. So one of the goals of these executive orders is to remove discrimination protections for individuals who identify as transgender or non-binary, which is something that had been expressly included, protections which had been expressly included in the 2024 Title IX regulations, which are no longer in effect. So in addition to Title IX, which again applies to educational entities that receive federal funding, there's also Title VII, and as Cassidy mentioned earlier, Title VII, which it includes protections on the basis of sex and other protected categories as well. And in the federal realm, there's also a case that you may be familiar with, Bostock v. Clayton County, Georgia, which is a 2020 Supreme Court case that held that Title IX includes a prohibition against workplace discrimination on the basis of sexual orientation, and held that Title VII, let's start again, includes a prohibition against workplace discrimination on the basis of sexual orientation or transgender identification. So just to note that about the case in particular, Bostock was a 6-3 decision, with Justices Alito, Thomas, and Kavanaugh dissenting. Justices Breyer and Ginsburg were part of the majority in that decision. And of course, now we know the majority of the Supreme Court justices currently sitting are Republican appointees. So given the current political climate, there's an expectation that Bostock is very likely to be challenged in the near future. But the thing to keep in mind is that it is still good law for now. So that is to say that under Title VII, individuals are still protected from discrimination on the basis of gender identity and sexual orientation. And employers must make sure that they're not discriminating on the basis of gender identity and sexual orientation. And they must be sure that they're not permitting a hostile environment of discrimination on the basis of sexual orientation or gender identity. One thing I did want to note for folks is that the EEOC, which is charged with enforcement of Title VII, is likely to align its enforcement actions with the executive orders, either in terms of the matters that the EEOC will choose to investigate, or on the flip side, what it will decline to investigate. So that's just something to keep in mind on the federal enforcement side. In the meantime, though, going back to my slides earlier on that tension between state law and federal law, a reminder that Massachusetts law provides robust protections under Chapter 151B against discrimination on the basis of sex, which includes sexual orientation and gender identity. And Massachusetts employers must ensure that their practices and policies don't permit discrimination on either category. Next slide, please. I did want to mention a couple of pending cases that may make their way up to the U.S. Supreme Court, and continuing on this discussion of sex discrimination. So the first case is a case that some school folks may be familiar with. Actually, both of these are school cases, but there have arguably some relevance to all employers. So I wanted to just talk about them briefly here, because either or both may have a good chance of making it up to the Supreme Court. So the first case is LMV Town of Middleborough. This got a lot of press locally here in Massachusetts. This is a case that involves a student who was suspended from school, public school, from wearing a t-shirt that said there are only two genders. The federal district court here in Massachusetts upheld the student was suspended from school for wearing the shirt, creating a hostile environment for other students. The parents sued, and the federal district court upheld the school's discipline of the student. Case got appealed to the First Circuit Court of Appeals. The lower court's decision was upheld, and the parents have appealed that case to the Supreme Court. So they've petitioned for what's called a writ of certiorari, basically asking the U.S. Supreme Court to hear their appeal. That's currently pending, but again, I think that there's some good likelihood that the Supreme Court will take that case up in the in the current political environment. So that's one case to keep an eye on. Again, that's a school case, but I think that there's a good chance if the court does take that, it could have implications for all employers as well as for schools and students and so forth. Another case I wanted to mention, again, also out of from here in Massachusetts, another case that is currently pending at the Supreme Court for determination on cert is a case called Foote v. Ludlow School Committee. This is another Massachusetts public school case in which a student had requested that the school staff refer to the student by a particular name and a set of preferred pronouns that were not those used by the family at home and not those that were assigned to the student at birth. In accordance with Massachusetts Department of Elementary and Secondary Education guidance, the school was respecting the students' wishes and using their preferred pronouns and preferred name. When the parents found out, they were not happy about that, and they had asked the school to stop, and the school had indicated that they would continue to respect the students' wishes. That case, parents sued, and the lower court upheld the school's decision. Similarly, case went up to the First Circuit. which upheld the lower court's decision. And that case is also has made its way up and is pending a decision on a request for cert. I mentioned that case a little bit different than the first case. It's more of a parental rights case than a First Amendment case, but it's just an interesting one. I know we have a lot of schools on the call today, so a couple of cases to keep an eye on, and we obviously keep folks posted as those cases develop. And again, another note on this point for charter schools in particular, this is a review for you all because I know that you all know the law so well and know the regulations, but under Massachusetts law, for charter schools by statute and by regulation, all charter schools are required to adopt a non-discrimination statement that includes prohibition against discrimination on the basis of sexual orientation and gender identity. That's sort of like hardwired into charter schools charters, which are approved by DESE. So that sort of additional layer of protection on the basis of against discrimination on the basis of sex is kind of baked into your charter, but I know that you all know that. But again, it just points out that, again, this sort of broader reminder that here in Massachusetts, we have a lot of protections in a lot of different areas for a variety of protected classes, and those are still good law. Next slide, please. All right, so I want to turn to a brief discussion about how some considerations for employers and reminders on the importance of balancing the rights of employees. Within the present uncertainty, and even within the boundaries of current law, employers need to be mindful of the need to balance employees' sometimes competing interests and rights. So there are First Amendment considerations, of course. So a couple of examples, you want to consider a situation, for example, where you have employee 1 who refuses to recognize employee 2's preferred pronouns. Employee 1 claims a First Amendment right to free speech. Employee 2 might allege that there's a Title VII hostile environment. And you may even have an employee 3 who witnesses some conversation about this between these employee 1 and employee 2, and then they themselves having alleging a hostile environment. So you want to remember the takeaway, I hope that you will all keep in mind, is that these situations can be, this balancing of employee interests can be quite complex. So you want to make sure that you are handling these situations thoughtfully and mindfully, and reaching out to counsel when you are feeling you need some additional guidance and support. We've seen this come up in the school context as well. For example, when a teacher doesn't want to respect a student's preferred pronouns. So again, all of these situations can be tricky, and you want to just make sure that you're balancing all rights carefully and equitably. So another example I wanted to give of how this can come up. This is a case that is a set of facts that has come up in a case that's currently pending in federal court in Georgia. This was a case involving an employee who was terminated for refusing to attend a mandatory unconscious bias training for DEI. And he claims that his termination was discriminatory because his employer's unconscious bias trainings implicitly and explicitly rejected his sincerely held religious beliefs, which are that there are the only immutable characteristic that should define humans is that we are made in God's image. And so that was his sincerely held religious belief, which he claimed prohibited him from attending the mandatory unconscious bias training. That case is currently pending, as I said, in federal district court in Georgia. Again, another one that will be interesting to watch if it makes its way up through the circuit court of appeals, possibly even to the Supreme Court. The takeaway here is that, again, conflicts between employees can be incredibly tricky to navigate. You want to remember, employers should remember, follow your own policies regarding discrimination and harassment and requests for accommodation. Do so consistently and with fidelity. Consult with counsel as needed. And be mindful of First Amendment rights, but also be clear in your employee handbooks and staff trainings that any posts made on social media should not reference the organization or suggest that the views are that of the organization. So that's good language to have in your employee handbooks. Again, what employees say outside of work is generally, their free speech right to do. But you want to just make sure that it's clear to employees that when you're expressing your views outside of work, online, that there is not a suggestion that the views are that of the employer. So that's a good reminder. So I want to hand things back to Cassidy now, who will share some updates for folks on employment-related best practices.
Okay, can you go to next slide, please?
Except where did it go?
That's all
Oh,
right. Okay. So we're gonna switch gears a little bit and talk about immigration. As I'm sure you're all aware, immigration enforcement is gonna be a major priority for this administration. The main federal agency that enforces immigration laws is Immigration and Customs Enforcement, or ICE, which falls under the Department of Homeland Security. So prior DHS guidance, prior to the current administration, restricted immigration enforcement in what was referred to as sensitive areas. And sensitive areas were places like schools, hospitals, and churches. Shortly after the new administration took office, the acting DHS secretary issued a directive which lifted these restrictions. And so as a result, ICE is no longer prohibited from going into sensitive areas to make arrests. So it might be important for your organization to adopt an ICE policy and protocol in the event that ICE agents do show up. And just some important things to keep in mind when adopting a policy. ICE agents need to have a warrant or consent to enter private spaces, but they do not need a warrant or consent to enter public spaces. So one thing your policy should do is delineate what are the public spaces and what are the private spaces at your location. So to use a hospital, for example, a public area would be something like a lobby, a waiting area, parking lot, and similar spaces, where a private area would be like exam rooms. In the school context, typically the whole school is considered a private space, at least the interior of the school, because for security reasons, schools are usually locked. People need permission to enter. And so in that case, the entire school would be a private area. If agents do show up and have a warrant, it's important to look at the warrant and see what it actually says. Make sure that it's signed by a federal judge. And always call counsel, and you can simply ask the agent to wait while you call your attorney. Also in the area of immigration are I-9 audits. As I'm sure you're all aware, federal law requires employers to retain a Form I-9 and documentation for their employees demonstrating their authorization to work in the United States. During the last Trump administration, there was an increase in I-9 audits, and we can expect that there will probably be a similar increase this time around. So officials from the Department of Homeland Security, Department of Justice, and the Department of Labor can inspect an employer's I-9 forms. Typically how it works is that the employer will receive a written notice of inspection at least 3 days prior to the inspection, although agents can also use subpoenas and warrants to obtain the forms without providing 3 days notice. But they might ask that employers bring the forms to an ICE field office, for example, or they might arrange to come to the employer's location and inspect the forms. The most effective way to prepare is to conduct a self-audit. There's a lot of helpful information about this on the USCIS website. That's US Citizenship and Immigration Services. I think we're going to drop that link in the chat. So that's a helpful resource for you. And as the slide says, you should consider working with counsel if you're going to conduct an I-9 audit so that findings will be privileged, although any errors that are identified during the audit will need to be corrected. And the link that we're sharing has a lot of detailed information about how to go about correcting those errors. Yeah, next slide, please. Okay, switching gears again, we're going to talk about some changes at the National Labor Relations Board, the NLRB. So as the slide says, on February 14th, the acting general counsel of the NLRB issued a memo rescinding several memos that were issued by the prior general counsel. So what is a general counsel memo? It's essentially just non-binding guidance that's issued by the general counsel, and it's used to instruct the NLRB's field staff about the general counsel's priorities. And they also provide helpful information for employers, unions, and workers about how the board is going to handle novel or controversial issues. And so when the new acting general counsel, William Cowan, came in, he rescinded this guidance that was issued by his predecessor under the Biden administration. And broadly speaking, that indicates that there's a shift in enforcement priorities. So just to quickly talk about some of the memos that were rescinded. The first one is 2103. So broadly speaking, the National Labor Relations Act, the NLRA, protects concerted activity that's undertaken for the purpose of mutual aid or protection, whether or not that activity is in the union context. So during the Biden administration, the board took a more expansive view of what constitutes mutual aid or protection, as well as certain activities that it viewed as inherently concerted. And essentially, this made it easier for workers to make out an unfair labor practice claim. The rescission of this memo indicates that the board is going to take a more narrow view of these concepts, which will in turn make it more difficult to make out a claim. And the consistent theme with all of these rescissions is that the board is adopting more of a pro-employer stance rather than a pro-worker stance. The next one is GC 2305. This memo discussed the McLaren-McComb decision, which was a 2023 board decision, which held that employee severance agreements that require employees to broadly waive their rights under the NLRA are unlawful, and specifically non-disparagement and confidentiality clauses. This is an area where the board has sort of flip-flopped recently. In 2020, there was a decision that found similar clauses in severance agreements to not be unlawful. McLaren-McComb overruled that decision. The rescission of this memo signals that the board is likely to flip-flop on this again. This decision might be overruled. Also, there was a section of the memo that addressed whether the McLaren-McComb decision applied retroactively, meaning whether it applied to agreements that were signed prior to the decision. The prior GC took the position that yes, it did apply retroactively. This rescission indicates that the board is not going to apply the decision retroactively while the decision is still good law. And then finally, we have 2308, which had declared that the proffer, maintenance, and enforcement of non-compete agreements in employment contracts and severance agreements violate the NLRA. This rescission indicates that the board is not going to view non-compete agreements as automatically invalid under the NLRA, and it's unlikely to pursue complaints against employers based on the proffer, maintenance, or enforcement of non-competes. Keep in mind, though, that Massachusetts has its own non-compete law, which went into effect in 2018. And under the Massachusetts non-compete law, non-competes are permitted in some narrow circumstances. So in Massachusetts, this might not have that much practical effect. All right, next slide, please. Okay, kind of along the same lines, the acting chair of the Equal Employment Opportunity Commission, the EEOC, has also signaled a change in enforcement priorities. This is the agency that's tasked with enforcing the employment discrimination laws that we talked about earlier. So I have the acting chair's statement here on the slide. I won't read the whole thing, but I'll just point out a couple of things. So we have the unlawful DEI motivated race and sex discrimination. We have protecting American workers from anti-American national origin discrimination. And then we have remedying other areas of recent under-enforcement. Essentially, it's turning Title VII on its head. It's prioritizing enforcement of anti-discrimination law in cases where the party claiming discrimination is not a historically discriminated against group. And this is going to be the EEOC's priority over the next few years. Some additional items relating to EEOC enforcement to be aware of. So the Federal Pregnant Workers Fairness Act requires employers to provide a reasonable accommodation to an employee based on pregnancy, childbirth, and related medical conditions. The EEOC had promulgated a final rule which included abortion in the definition of pregnancy, childbirth, and related medical conditions, which meant that employers would have potentially needed to accommodate an employee who had had an abortion. And the acting chair has indicated that she intends to reconsider portions of the final rule, which she believes are unsupported by the law. There's also a lawsuit pending in federal court challenging the final rule. The DOJ has moved for a stay in the lawsuit based in part on the fact that the EEOC is likely not going to be enforcing this part of the rule. And so it's safe to assume that the requirement to accommodate employees for abortion-related conditions will not be enforced by the EEOC. But keep in mind that this type of accommodation might be required under the Massachusetts Pregnant Workers Fairness Act. And then finally, because the acting chair has signaled an intention to enforce anti-American national origin discrimination, there could be an increased focus on employers who rely heavily on the H-1B visa program for workers. In 2024, there was a case against Cognizant, which is an IT consulting and outsourcing company, which employs a lot of H-1B visa holders. That lawsuit alleged a pattern of discriminatory practices towards non-Indian workers. A jury in LA found in favor of these non-Indian employees and awarded damages. So given the focus on immigration and sort of reverse discrimination type cases, this could be an increased area of enforcement for the EEOC. All right, I think we have a few minutes left. I'm going to turn it back over to Bettina to discuss some key takeaways and next steps for your organizations.
All right, thanks, Cassidy. Okay, so as we've learned so far, the executive orders and federal guidance documents can seem like they're coming fast and furious, and it can be dizzying for employers to make sense of it all and to know what to do. With all the cases making their way through the courts, in many situations, the best action might be to just sit tight at this point in time instead of rushing to change policies, procedures, and practices. However, while there may be no need to rush to make changes at the moment, there are steps that employers could and should be taking at the moment to best position themselves or best protect themselves. So the first thing and the main thing is to assess your risk, right? So first, you want to consider, in the realm of DEIA, what role does DEIA play in your organization's mission? Is it, something that you do in compliance with the law, or is it really like at the heart of your organization and what your organization is really designed to do? Second, how reliant is your organization on federal funding? Is it a major portion of your funding, or is it just a sliver or a slice of it? Again, the federal funding freeze is on hold for now, but again, knowing, and thinking about your sources of funding and the potential risk is important. Next, you want to review existing internal and external facing narratives, including social media and other website and other media, just to be, not to say that you will necessarily want to go out and again rush to change or scrub your websites and social media, but you want to be aware what's out there, not just sort of the real obvious things like your LinkedIn and Instagram and website, other stuff that might be out there that you may have forgotten about. You want to just be aware of what's out there. Remember that whistleblowers are out there, and they've been encouraged and incentivized to report potential violations of the various executive orders and other recent guidance and directives. So you want to at least be aware, even if you're not taking action, to make changes at this time. Next, you want to make sure to review relevant policies as needed, including, for example, your ICE policy and protocol, to make sure if you don't have one that you adopt one if you think you need one, which is good practice. Certainly schools should do that, or you're updating it as needed if you haven't looked at it in a while. You want to look through your affinity and look at your affinity and employee resource groups through a fresh lens, right? So while such groups are not illegal, as Jill explained, organizations need to be thoughtful about how you promote them. So you want to make sure you're not limiting membership or giving the appearance of limiting membership to those types of groups, or discouraging certain categories of individuals from participating. I know we're at time. Just a couple of other sort of takeaways. You want to monitor your internal compliance practices. Again, Cassidy mentioned doing an internal I-9 audit if you haven't done one in a while. Making sure that staff are trained on anti-discrimination policies and procedures, making sure policies and procedures are implemented equitably and with fidelity. Paying attention to subsidiaries and partner organizations as well, and staying informed. So communicating with counsel, communicating with other organizations with similar missions and interests, And the last thing I wanted to just mention, in addition to the communicate with counsel as needed, if you receive a notice or correspondence from any federal agency, don't sit on it. So reach out to counsel, make sure you're not, if it's confusing or don't understand it, don't just sit on it. Make sure you reach out and get some guidance, because those are important things to pay attention to. So thank you very much for your time. And I think we are at time, and I don't think we have time for questions, but as Jill mentioned earlier, we'll definitely be aggregating the questions that folks have submitted either today while the webinar has been live or through the registration. And we'll be including those in an FAQ that we're going to circulate to folks who attended today. So thank you so much for attending. We appreciate your joining us today.
Thank you.